Don't give up on that. Sounds like you're giving up on him. Do not give up on him. No, can you please, Edward, now?
Jamie Varley was born in 1989 and worked as a teacher at South Shore Academy in Blackpool, a secondary school where he was employed as head of year and design and technology instructor. His partner, John McGowan-Fazakerley, also lived with him. In 2023, both men applied to adopt a child. They underwent a two-stage adoption assessment beginning in September 2022, comprising at least 8 home visits by social workers. The assessment process evaluated their suitability as adoptive parents, including discussions around education, health, identity, childcare practices, and their motivations for adopting. In January 2023, they completed Stage 2 of the adoption process. An adoption match was arranged with Preston Davey, a boy born on June 16, 2022. Preston had been taken into care by Oldham Council immediately after birth at 5 days old, and had been placed with foster parents Sandra and Paul Cooper, experienced foster carers with 27 years in the field. Preston developed normally in foster care and was described by social workers as healthy and thriving. Introductions between the prospective adopters and Preston began in February 2023 at the foster carer's home. On March 9, 2023, the adoption match was formally approved. Preston moved in with Varley and McGowan-Fazakerley on April 1, 2023, at their home on Staining Road in Staining, near Blackpool. Varley took a year off work to look after the child. Preston was placed with men who appeared to be a stable couple presenting themselves as capable, loving adoptive parents. Neither social worker, Amy Shepherdson of Oldham Council or Victoria Riadet of Adoption Now, reported any concerns during the introductions or at the time of placement. Preston's foster mother Sandra Cooper, however, later reported she had a gut feeling something was wrong when the adoption was finalized. Between April 1 and July 27, 2023, a period of less than 4 months, Preston suffered approximately 40 injuries, including 30 external bruises, internal bleeding, and a fractured left arm. On May 25, 2023, approximately 3 weeks after arriving at the home, Preston was brought to Blackpool Victoria Hospital by Varley alone. McGowan-Fazakerley was at work in Manchester. Medical notes documented Preston as unresponsive, floppy, breathing ineffective, and in need of resuscitation. Varley reported the child was having a seizure and was not breathing. Hospital staff treated Preston, and he was discharged. The second hospital visit occurred on June 30, 2023, when Preston was brought in with breathing difficulties. Varley was noted as angry because we rang the police the last time, referring to the May 25th incident. He was given antibiotics. Hospital staff noted bruising to Preston's forehead. Varley and McGowan-Fazakerley explained the bruising as having been caused by a toy box falling on the child. On July 5, 2023, the child sustained a fractured left arm. Varley told hospital staff on July 6 that Preston had kicked his feet while being lowered into his cot, and he heard a pop in the child's elbow. Preston was fitted with a plaster cast. Hospital records documented the arm was pulled during the incident. In his police interview, Varley later claimed to friends he had caught him when falling, but told another friend the injury was accidental. During this 4-month period, Varley recorded indecent images and videos of Preston. Police recovered evidence from his mobile phone showing recordings throughout this time. One video lasting 14 minutes and 31 seconds showed Preston alone in a bathtub. Varley claimed he set his phone to record to observe how he reacts to his own company. In footage, Preston is distressed and whimpering. When asked by police why he did not comfort the child, Varley stated he was keeping an eye on him with no intent to hurt him. A 35-second video showed Preston lying on a bed struggling to breathe. A consultant in pediatric respiratory medicine concluded Preston bore signs of respiratory failure. His lips appeared bluish, breathing labored, and Varley remained completely silent, never attending to the child or seeking medical assistance. On July 8, 2023, Varley sent a text message to McGowan-Fazakerley stating, "I strangled him." This message was sent on the afternoon of July 8, 3 weeks before Preston's death. The prosecution characterized this as an explicit admission. In another message on the same day, Varley stated he would fight you till the day I die in reference to facing allegations. During trial, the prosecution presented evidence that Varley had made disclosures to a former work colleague at South Shore Academy that he was struggling mentally, was not bonding with Preston as hoped, and had thoughts of drowning or suffocating the child. However, he claimed he would never act on these thoughts. The prosecution argued that in the context of subsequent events, it was inconceivable he would not have shared these dark ideations with his partner McGowan Fazakerley. On July 27, 2023, Preston died. The sequence of events was documented in detail. Varley was alone with Preston. McGowan Fazakerley was at work. According to the prosecution, Varley sexually assaulted Preston, causing internal injuries. He recorded video footage showing Preston in respiratory distress, but did not seek medical help. Both men then rushed the unconscious child from their home to Blackpool Victoria Hospital at approximately 1820 British Summer Time. Medical staff worked for nearly an hour to resuscitate Preston, attempting to revive him in cardiac arrest. At 1920, approximately 1 hour after arrival, Preston was pronounced dead. Varley was present in the hospital. Footage captured by police body-worn cameras showed him in the bereavement room. He was visibly distressed, wailing, and saying, "I'm done. It's my fault." He repeatedly said, "He's my baby boy. He's got to wake up." At one point, he stated, "I'm going to hell." He paced and said, "I tried to go in, but my mum wouldn't let me hold him." Later footage showed both defendants together in the bereavement room at just after 2300 hours, with McGowan Fazakerley attempting to console Varley and telling him the death was a tragic accident. Varley, still cradling the child, responded, "I probably won't see you again," suggesting awareness of imminent arrest or prosecution. Varley's initial explanation to police was that he had left Preston in the bath for 3 to 4 minutes and returned to find the child face down in the water. This account contradicted forensic and medical evidence obtained from the post-mortem examination conducted by Home Office pathologist Dr. Alison Armour. Dr. Armour's findings concluded that Preston had not drowned. Instead, she determined he was a victim of abusive trauma, non-accidental injuries, and sexual abuse. The autopsy revealed Preston's cause of death as acute upper airway obstruction caused by either deliberate smothering or the insertion of objects into his mouth. Postmortem findings also documented bruises to Preston's forehead, back of throat, mouth and bottom, and internal bleeding in his lungs. Examination of Preston's lung tissue conducted after death disclosed findings consistent with earlier episodes of respiratory obstruction, suggesting the fatal incident was not isolated, but part of a pattern of deliberate obstruction. Medical examiners had previously attributed earlier hospital presentations to nonspecific viral chest infections, but lung tissue analysis post-mortem revealed evidence of repeated trauma. The prosecution, led by Peter Wright KC at Preston Crown Court, presented opening statements on April 20, 2026, describing the case as inevitably a highly emotionally charged case involving the death of a very, very young child. Wright told the jury of 6 women and 6 men that while the tragedy appeared to involve a dreadful accident, the evidence revealed a much more sinister pathology. He stated, "We say the evidence demonstrates that he was murdered by one of the people entrusted with his well-being, one of his proposed adoptive parents. We say the person responsible for killing Preston Davey was the defendant, Jamie Varley." Wright emphasized that Preston had been routinely ill-treated, sexually abused and physically assaulted during his time in the defendant's care. He described Preston as a perfectly healthy boy before adoption, contrasting sharply with the injuries he sustained within 4 months. The trial, which began April 20, 2026, was expected to last 6 to 8 weeks. Varley was charged with murder, manslaughter, 2 counts of assault by penetration, 5 counts of cruelty to a child, grievous bodily harm, sexual assault of a child, 13 counts of taking indecent photos or videos of a child, 1 count of distributing an indecent photo of a child, and 1 count of making an indecent photo. McGowan Fazakerley was charged with causing and allowing the death of a child, 3 counts of child cruelty, and 1 count of sexual assault of a child. Both men denied all charges. At South Shore Academy, following Varley's arrest in 2023, he was immediately suspended. The school, then part of Bright Futures Education Trust, suspended him on full pay as legally required. After the school transferred to Sidari Multi-Academy Trust in October 2023, he remained suspended and was barred from school premises, unable to contact pupils or colleagues. The school issued a statement acknowledging, "Our thoughts are with the family of Preston Davey and all those affected by this case." As of May 2026, the trial continued at Preston Crown Court in Lancashire with testimony ongoing and evidence being presented to the jury. Marc Fogel was born July 28, 1961, in Pennsylvania. He attended Indiana University of Pennsylvania and became a history teacher. Over 27 years, he taught at international schools in Colombia, Malaysia, Oman, Mexico, and Venezuela. In 2012, he and his wife Jane relocated to Moscow to work at the Anglo-American School, AK-12 institution founded by the American, British, and Canadian governments in 1949. Teachers there held diplomatic immunity until 2020, when Russia revoked the status. Fogel had also worked at the U.S. Embassy in Moscow before moving to the school. By 2021, after 9 years at the Anglo-American School, he planned one final year before retirement. He was an award-winning teacher known for engaging students, teaching history, and coaching softball. In 2021, Fogel developed chronic pain affecting his back, shoulder, and knees, stemming from spinal surgery. A doctor in the United States prescribed medical cannabis to manage the pain. Fogel obtained the cannabis legally in the United States, where it was prescribed and documented in his medical records. Cannabis is entirely illegal in Russia. There is no legal medical marijuana provision in Russian law. Fogel stated he was unaware of Russia's absolute ban on all forms of cannabis. On August 14, 2021, Fogel and his wife returned to Russia after time in the United States. They flew from New York to Moscow's Sheremetyevo International Airport. The cannabis was hidden inside contact lens cases and e-cigarette cartridges, wrapped in plastic and placed inside his sneakers. Customs personnel detected the concealed items. Drug detection dogs identified the contraband. Officers found approximately 17 grams of cannabis and 8 grams of hash oil, less than 1 ounce total. Russian law defines a large amount of marijuana as 100 grams or more. Despite carrying far less than this threshold, Fogel was charged with large-scale drug smuggling. On August 15, 2021, Fogel was arrested. Russian authorities did not publicly announce the arrest for 5.5 months. In January 2022, the Russian Interior Ministry released details, stating Fogel had attempted to smuggle marijuana carefully disguised in his luggage. The ministry alleged he could have used his former diplomatic status to establish a drug smuggling route for distribution at the school. This allegation was never substantiated with evidence. Russian state media propagated the claim, but Russian prosecutors themselves did not pursue this theory in trial. Fogel was held in a Moscow detention center for 10 months awaiting trial. His case was assigned to Khimki City Court in the Moscow region, the same courthouse where WNBA player Brittany Griner was being tried on identical charges. Griner had been arrested in February 2022 with cannabis oil in e-cigarette cartridges. Fogel's trial concluded 2 days before Griner's verdict. During trial, Fogel pleaded guilty to smuggling and possessing drugs. He maintained the cannabis was for medical purposes and that he was unaware of Russia's absolute prohibition. The court noted his exemplary teaching record, sincere remorse, and lack of prior criminal history, yet sentenced him to 14 years in a maximum security penal colony, extraordinarily disproportionate by Russian standards. In the same court, a Russian national received 8 years for smuggling 1.5 kilograms of various narcotics. Comparable cases involved 105 kilograms of cocaine, 15 years, and 115 kilograms of heroin, 17 years. Murders and burglaries typically received lesser sentences. The longest comparable sentences for foreign nationals involved individuals used as political leverage. In October 2022, Fogel was transferred from the Moscow detention center to Rybinsk penal colony, approximately 4 hours from Moscow. Russian penal colonies are documented as facilities with harsh conditions, including overcrowding, abuse by guards and inmates, limited access to health care, food shortages, and inadequate sanitation. Fogel, then 61 years old with chronic pain from spinal surgery and mobility issues from a replacement knee operation requiring a pronounced limp, was incarcerated in a maximum security facility. While imprisoned, he taught English to fellow inmates, continuing his role as an educator. His family received primarily Russian language letters, indicating limited consular access. For years, his family had minimal direct contact. When asked how he was coping, conversations ended in what his sister described as dead silence. Fogel's family began advocating for his release, arguing the sentence was unjust and a 14-year term constituted a de facto death sentence for a man of his age and physical condition. In August 2022, a bipartisan group of United States senators called upon the State Department to designate Fogel as wrongfully detained, a formal classification that would prompt the U.S. government to actively negotiate for his release. The Biden administration initially declined to make this designation, despite Fogel's case being virtually identical to that of Brittany Griner. Griner was designated wrongfully detained in February 2022 and released in a prisoner swap in December 2022, exchanged for Russian arms dealer Viktor Bout. Fogel was excluded from this exchange and from a subsequent prisoner exchange in August 2024 involving journalist Evan Gershkovich and former Marine Paul Whelan. In August 2022, Fogel appealed his sentence. The Moscow Regional Court upheld the verdict on August 25, 2022, maintaining the 14-year sentence without modification. His family received only Russian-language letters from Fogel, indicating limited consular access and restricted communication where correspondence was censored. For years, his family had little direct contact. His sister and Fogel described the situation as existing in a black box, unable to have honest conversations and unable to provide direct support. Fogel's family lobbied for him to be designated as wrongfully detained, a formal classification that would prompt active U.S. government negotiations for his release. In August 2022, a bipartisan group of United States senators called upon the State Department to make this designation. The Biden administration initially declined, despite Fogel's case being virtually identical to that of Brittany Griner. Griner had been designated wrongfully detained in February 2022 and released in a prisoner swap in December 2022, exchanged for Russian arms dealer Viktor Bout. Fogel was excluded from this exchange and from a subsequent prisoner exchange in August 2024 involving journalist Evan Gershkovich and former Marine Paul Whelan. On August 1, 2024, National Security Advisor Jake Sullivan officially described Fogel as wrongfully detained, the first time a U.S. government official had made this designation. This shift in status opened the possibility of formal diplomatic negotiations for his release. A documentary about Fogel's case, titled "Did You Forget Mr. Fogel?" was released in 2024, increasing public awareness. The documentary was screened at the United States Capitol on July 22, 2024, for senators including Bob Casey and John Fetterman, and Representatives Chris Deluzio, Mike Kelly, and Guy Reese-Genthaler. The increased visibility contributed to political pressure on the administration to pursue his release. On February 11, 2025, Marc Fogel was released by Russian authorities following diplomatic negotiations headed by President Donald Trump. Trump's Middle East envoy, Steve Witkoff, was instrumental in negotiations. Fogel had served 3.5 years of his 14-year sentence in Rybinsk penal colony. He was released in a prisoner exchange involving Alexander Vinnik, a Russian cybercriminal detained in the United States. Upon arrival in the United States, Fogel was welcomed at Joint Base Andrews in Maryland before being taken to the White House, where President Trump greeted him. Wrapped in an American flag, Fogel stated he felt like the luckiest man on earth. He thanked Trump and officials involved in negotiating his release, describing them as heroes. U.S. Secretary of State Marco Rubio publicly confirmed Fogel's release. Fogel's family released a statement expressing they were beyond grateful, relieved, and overwhelmed, calling the preceding years the darkest and most painful period of their lives, and stating they could now look forward to the future with hope. Fogel's case exemplified how Russia's judicial system can function as a mechanism for political leverage. His sentence bore no proportional relationship to his offense compared to Russian sentences for equivalent or more serious drug crimes. The prosecution's claims about him distributing drugs to students at the school were abandoned by prosecutors themselves and never substantiated. The timing of his sentencing, during active prisoner exchange negotiations involving high-profile American detainees, and the explicit mention of his case in Russian state media as potential trade bait indicated his detention, served a political rather than purely judicial purpose. His status as a U.S. government employee, however nominally, and his position at a school backed by American, British, and Canadian governments rendered him valuable leverage in negotiations between Moscow and the West. His case remained publicly less visible than higher-profile detainees like Paul Whelan or Brittany Griner, contributing to his extended imprisonment before diplomatic movement on his behalf accelerated. Jeremy Forrest was a 30-year-old married mathematics teacher at Bishop Bell Church of England School in Eastbourne, East Sussex. His wife, Emily Forrest, was 32 years old. He had been employed at the school as a mathematics instructor and was responsible for teaching multiple classes. Forrest was also a part-time musician who performed under the stage name Jeremy Eyre. In May 2012, Forrest published a blog post under his music name with the title, "You Hit Me Just Like Heroin," in which he wrote about a moral dilemma, a reference understood by those close to the case to relate to his inappropriate relationship with a student. His victim was a 15-year-old girl at his school, identified as Megan Stammers. She had first developed a crush on Forrest when she was 14 years old. Forrest deliberately and systematically exploited this crush and groomed her over several months. The grooming process was methodical and premeditated. Forrest engaged Megan via Twitter, using social media to build the relationship beyond the classroom setting where direct observation by school staff was possible. He established private contact with her through this channel, isolating her from potential intervention by parents or school authorities. Within weeks of sustained contact, he told her, "I love you," language designed to reinforce emotional dependence. He first kissed her in a classroom at the school itself, a deliberate and direct breach of his position of trust and authority. Over the subsequent 4 months, Forrest engaged in frequent sexual activity with Megan. According to trial testimony from the girl herself, they had sexual intercourse up to 8 times in a single night. These acts occurred in his car, in hotels, and at his marital home, with the girl often in her school uniform at the time of pickup or during contact. Forrest sent Megan indecent images of himself, showing his naked torso with his hands down his underpants. These communications served to further enmesh the victim in a pattern of sexual expectation and normalization of inappropriate conduct. Throughout this period, Forrest's wife Emily remained completely unaware of his actions or his actual intentions. According to witness testimony presented at trial, on the evening immediately before he absconded with Megan, Forrest sat with Emily at home, tucked her in, and told her he loved her. He then boarded a ferry to France the following morning, sending Emily a text message reiterating that he loved her as he departed. This final message to his wife represented a continuation of his pattern of deception. By September 2012, Forrest had become aware that the school and potentially police authorities were becoming suspicious of his relationship with Megan. Teachers and staff had detected indicators of inappropriate contact. This fear of exposure prompted his decision to abduct the girl and flee the country to avoid arrest and prosecution. On September 20, 2012, Forrest and Megan boarded a cross-channel ferry together heading toward Calais, France. CCTV footage from Dover Port captured them boarding the ferry in his car. They carried return tickets suggesting a temporary departure, but made no intention to use them to return to Britain. The pair traveled to France with the ostensible plan to establish a new life together across the Channel, free from the constraints of his married status and his position of authority. A Europe-wide search was rapidly launched by British and international authorities. Sussex police worked with Interpol and coordinated with French law enforcement to locate the pair. An international arrest warrant for Forrest was issued on charges of child abduction. Megan's family made public appeals for her safe return and for information about her whereabouts. Her father Martin and stepmother Tracy appeared in media appeals, with her stepmother stating to reporters, "This is completely out of character for Megan. We don't know how to deal with this. She should be at home with us. She is the most beautiful and loveliest young girl ever, and we just want her home safe." Megan's mother issued her own separate plea to her daughter. "Sweetheart, I don't care what you've done or why, I just want you home." On September 28, 2012, French police stopped Forrest and Megan in Bordeaux on the main street, known as Rue Sainte-Catherine, at approximately 1:15 p.m. local time. According to police sources quoted in French media, they were reportedly heading to a job interview, suggesting they had established some form of routine in the city. The girl was immediately taken into protection by French authorities. Forrest was arrested on suspicion of child abduction under his European arrest warrant. He was transported by police in an unmarked vehicle, hidden from view by officers with a towel covering his head to shield him from media scrutiny, and taken to a police facility for processing. Forrest was held in French custody, pending extradition proceedings. On October 2, 2012, he was extradited to the United Kingdom and flown to Gatwick Airport. His head was covered by a towel to shield him from media scrutiny and photographers. He was placed directly into a police van at the tarmac. On October 10, 2012, after formal processing by Sussex police investigators, Forrest was formally charged with child abduction. On January 25, 2013, appearing at Lewes Crown Court via video link from HMP Lewes, Forrest pleaded not guilty to the child abduction charge. His defense solicitor suggested a narrative that he took Megan to France to prevent her from harming herself, claiming she had made statements about suicidal ideation and potential self-harm. The trial commenced on June 10, 2013, at Lewes Crown Court before a jury of 12. The proceedings lasted 8 days, during which the prosecution presented comprehensive evidence of Forrest's systematic grooming via Twitter, his multiple sexual contacts with Megan in various locations, his communications of indecent images, and his orchestrated abduction when he feared discovery and prosecution. The girl herself testified regarding the nature of their relationship, how the grooming process began and developed, and her physical and emotional experience during both the grooming period and their time in France. Forrest did not give evidence in his own defense, choosing to remain silent and not subject himself to cross-examination by the prosecution. Forrest's wife Emily testified during the trial about their marriage, their relationship, and her complete lack of knowledge regarding his activities. Judge Michael Lawson QC called for a break in proceedings as Emily Forrest broke down in the witness box. She gestured at her estranged husband in the dock and said, "It's really distracting," before being escorted from the courtroom in tears. It was the first time she had seen her husband since he allegedly absconded with the 15-year-old student. Following the guilty verdict, Forrest appeared for sentencing on June 21, 2013. At this hearing, he pleaded guilty to 5 additional counts of sexual activity with a child, offenses he had not originally been charged with due to legal complications surrounding his extradition. Judge Michael Lawson QC sentenced him to 5.5 years in prison. The judge stated, "Your behavior in this period has been motivated by self-interest and has hurt and damaged many people. Her family, your family, staff and pupils at the school, and respect for teachers everywhere." The judge made specific findings regarding Forrest's conduct. He noted that Forrest had not given evidence during the trial and questioned inconsistencies in Megan's testimony between her police interviews and her court evidence. The judge observed that her testimony aligned with Forrest's defense narrative that he took her to France to prevent self-harm. Sussex police later conducted an investigation to determine whether Forrest had attempted to contact Megan to influence how she gave evidence in court, though this investigation's outcome was not widely publicized. Forrest's sister, Carrie Hans Paul, attended the sentencing hearing. His mother, Julie Forrest, was present in court as well. Both family members were visibly distressed as the sentence was announced. Forrest's father, Jim Forrest, age 59, an IT worker, had previously appealed publicly for his son to return Megan to her family, stating that he had attempted to contact Jeremy by phone, but his calls went unanswered. The case generated significant controversy regarding institutional safeguarding. Evidence emerged that school staff at Bishop Bell had warned Forrest about his conduct 7 months before the abduction occurred. The Education Authority also faced criticism for not communicating suspicions to parents or authorities earlier. The case exposed vulnerabilities in recognizing and reporting inappropriate teacher-student relationships and the effectiveness of safeguarding protocols in schools. Forrest served his sentence and has since been released from prison, subject to release conditions and notification requirements as a convicted sex offender. Mark David Latunski was born March 28, 1969, in Morris, Michigan. He graduated as a valedictorian, earned a chemistry degree from the University of Michigan, and obtained a master's degree in physical and organic chemistry. He worked as a research chemist at Flint Group, earning over $100,000 annually. He married Emily in 2001 and had 4 children. They divorced in 2013. Despite Emily's documented concerns about his mental health, Latunski received unsupervised visitation rights. In 2013, he kidnapped 2 children and refused to return them. He was arrested, evaluated as incompetent to stand trial, and released with charges dismissed in 2015. Court documents from his 2013 divorce reveal diagnoses of severe chronic major depression with psychotic features, paranoid schizophrenia, and borderline personality traits. When off antipsychotic medication, he exhibited obsessive behavior with torture films, erratic speech, sleep deprivation, animal abuse threats, false paternity claims, and poor hygiene. He frequently discontinued prescribed medications, deteriorating rapidly. In December 2016, Latunski remarried Jamie Arnold, who was unaware of his severity. By 2019, Arnold recognized serious decline. Latunski made false accusations that his employer was contaminating products. He was terminated in February 2019 for erratic workplace behavior. He then advertised on dating and escorting platforms under the alias Will Allos Vilas. He was arrested in July 2019 for failure to pay child support. In August 2019, Emily filed to suspend parenting time, stating he discontinued medication and accused her brother of poisoning his water. A custody hearing was scheduled for December 24, 2019. Throughout 2019, Latunski's home in Bennington Township, Shiawassee County, contained a basement room with restraints and chains. On September 26, 2019, a man called 911 claiming he was drugged and chained in the basement. Police took no action. On October 10, 2019, James Carlson, 48, from New York, called 911 after cutting himself free with a butcher knife. He stated he believed he was drugged. Police questioned him, determined the encounter was consensual, and dropped him at a gas station without filing charges or investigating Latunski. Carlson was stranded without money or transportation. He called Latunski, who told him his return ticket was not valid for another week. Carlson remained at the property for 7 days, participating in further sexual acts with Latunski. In November 2019, another man, approximately 29 years old, fled the home covered in blood. A neighbor witnessed this man screaming that Latunski wanted to hurt him. Police arrived, treated his injuries, and filed no charges. Latunski had chased him over an expensive leather kilt he was wearing. Kevin Bacon was 25 years old, worked as a hairdresser in Swartz Creek, and studied psychology. He struggled with depression and suicidal ideation. A month before his death, he cut himself and admitted himself to a psychiatric facility. He was dissatisfied with life in Swartz Creek and lacked resources to relocate. On December 24, 2019, around 5:20 p.m., he left his apartment where he lived with roommate Michelle Myers. He told her he was meeting a man from Grindr and would be home late. He was never heard from again. His family reported him missing December 25th after he failed to appear for a family breakfast. Police found his Honda Civic in a Family Dollar parking lot, less than 5 miles away. His phone, wallet, and clothing were inside. Police traced his Grindr communications to Marc Latunski's account and arrived at his home on December 27th. Latunski permitted officers to enter without resistance. In a hidden basement room, police found Bacon's completely naked body suspended upside down from a pulley system attached to the ceiling, hanging by the ankles. During his interrogation, Latunski admitted he stabbed Bacon in the neck, slit his throat, hanged him upside down from the rafters, cut off his testicles, cooked them, and consumed them. He stated he planned to use Bacon's blood and bones to fertilize plants and prepare muscle tissue as jerky. Detective Sergeant James Moore testified that Latunski's account was premeditated. Latunski had asked Bacon about health conditions prior to meeting, acquired his address before meeting him, prepared clothing, blindfold, earmuffs, and restraints. The two met at the Family Dollar parking lot where Bacon removed his phone, wallet, and clothes, changed into Latunski's clothing, and was driven 24 miles to the property. The killing method mirrored the violence Latunski had practiced on at least 2 other men in preceding months who survived. Latunski was initially found incompetent to stand trial in February 2020. He was placed under psychiatric evaluation at the Saline Center for Forensic Psychiatry. In January 2015, approximately 10 months after the murder, he was evaluated again and deemed restored to competency to stand trial. Legal proceedings resumed. Latunski initially pleaded not guilty, and his defense attorneys advised him to proceed to trial with an insanity defense, arguing that he would be more appropriately placed in a psychiatric hospital than a prison facility. However, in September 2022, Latunski overrode his attorney's recommendation and entered a guilty plea to open murder and to the disinterment and mutilation of a dead body. His plea meant the court would now determine the degree of murder, first degree, second degree, or manslaughter, which would determine his sentence and parole eligibility. On October 18, 2022, Judge Matthew Stewart conducted a hearing to determine the classification of the offense. The defense argued that the murder was not premeditated, pointing to the fact that Latunski had asked Bacon about his health prior to their meeting, and that he had allowed police to enter his home without resistance. The prosecution countered with evidence of clear premeditation. Judge Stewart reviewed Latunski's interrogation statements, his prior pattern of violence against other men, and the systematic nature of the murder. Stewart noted that Bacon had messaged Latunski prior to meeting, asking, "You are going to keep me safe, right?" in apparent recognition of potential danger. The judge found that Latunski had designed and executed the murder with calculated intent. Stewart determined that the offense constituted first-degree murder and that the crime had been perpetrated with cold calculation. Under Michigan law, first-degree murder carries a mandatory sentence of life imprisonment without the possibility of parole. On December 15, 2022, Latunski appeared before Judge Matthew Stewart for sentencing. He was 53 years old. He was shackled at the waist and had grown a long beard during his incarceration. He declined to make any statement before the court. Judge Stewart imposed a sentence of life in prison, without the possibility of parole on the first-degree murder conviction, and a concurrent sentence of 11 months to 120 months on the charge of disinterment and mutilation of a dead body. Victim impact statements were presented to the court. Bacon's mother, Pamela Bacon, wrote that their world had been shattered and that Christmas would never be the same for the family. She stated, "In your sick, twisted mind you probably don't think you did anything wrong, but in reality, you took our world away." Bacon's father, Carl Bacon, expressed that he was satisfied to see Latunski imprisoned for life. Bacon's sister also addressed the court. The judge stated before rendering his sentence that he hoped it would provide some small measure of comfort amid what he acknowledged was an enormity of hurt. The case raised questions about police response to assault and kidnapping allegations involving male victims, particularly those in the LGBTQ community. Michigan State Police Lieutenant David Kaiser had stated in January 2020 that prior victims had been reluctant to press charges, noting that many individuals did not wish to merge their professional and personal lives. However, critics of the police response, including Bacon's roommate Michelle Myers and James Carlson's attorney John Marco, argued that police had sufficient authority to investigate Latunski based on the 911 calls and the corroborating evidence of violence, even without victim cooperation. Marco contended that had police interviewed and questioned Latunski following Carlson's escape in October 2019, Kevin Bacon might not have been murdered. In June 2020, James Carlson filed a federal civil lawsuit against Latunski, seeking unspecified damages for false imprisonment, assault, battery, intentional infliction of emotional distress, and negligence. During his deposition in 2020, Latunski invoked his Fifth Amendment privilege in response to all 122 questions posed to him. Marc Latunski remains incarcerated at a Michigan correctional facility, serving his sentence of life without parole. Kevin Bacon was cremated. His family and friends describe him as a generous person who would give his last dollar to help others. The case became a cautionary example regarding the use of dating applications and the importance of meeting in public spaces, informing trusted individuals of one's whereabouts, and remaining alert to behavioral red flags. It also exemplified systemic failures in mental health intervention and criminal investigation practices that allowed a pattern of violence to escalate unchecked through the month of December 2019.